Unit 6 Real Estate Contracts. A real estate contract is a contract between parties for the purchase, sale, exchange, or other real estate transaction. The sale of land is usually dictated by the laws and practices of the jurisdiction in which the land is located. These type of contracts are typically bilateral contracts, agreed to by two parties, should meet the legal requirements specified by contract law in general and should also be in writing to be enforceable. In summary, there are basically four types of real estate contracts: purchase agreement contract, contract for deed, lease agreements, and the power of attorney contract, SAGN, 2017. They each have different uses and conditions. In this unit, we will cover the different types of real estate contracts and transfer the foundational knowledge to make informed investment decisions and help investors make sound decisions. As previously mentioned, there are four main types of real estate contracts. 1. Purchase agreement. This is one of the most common types of real estate contracts. As suggested by the name, this is a contract that defines an agreement between the buyer and the seller of a specific real property. This type of real estate contract includes all the standard elements of a contract: purchase price, identification of the real estate property, party identification, signatures, legal purpose. If the contract calls for a legal action, it will be considered void. The closing date for the transaction, etc. 2. Real estate assignment contract. A real estate assignment contract is used, principally, in a wholesaling investment strategy, in which you find a distressed property, secure it under contract and assign the contract over to a second buyer, usually at a small profit to you. The concept of real estate assignment contracts is very similar to a regular purchase agreement. Often, an assignment contract simply has the addition of useful extra information. For example, you might add the following phrase to a purchase agreement: John Smith, and/or assigns. When people refer to wholesale real estate contracts, this is the document they mean. The assigns part gives you the opportunity to lock up a property with a purchase contract and pass along that property to someone else if you so desire, SAGN, 2017. These additional phrases provide a tremendous amount of flexibility to the investor. 3. Lease agreement. These real estate contracts draft an agreement between the lessor, also known as the property owner landlord, and the lessee, also known as the tenant. This kind of agreement specifies significant factors such as the rent amount, security deposit, utilities, etc. Lease agreements are intended to avoid future issues between the lessor and lessee, and protect both parties if something unforeseen happens. 4. Power of attorney. Power of attorney documents are a form of real estate contract, though not used exclusively in a real estate context, and can be extremely useful in certain situations. This is the case specifically when someone is not able to sign a real estate contract, whether because they are out of the country or incapacity. This document gives another party the power to sign on their behalf. As mentioned in the KPMG's Cyprus Real Estate Market Report, 2017, in 2016 there was one of the largest annual increases in the total property sales contracts submitted at the land registry noted in Cyprus. Moreover, 2017 saw an even higher number of deeds of sale submitted. This recovery of the real estate market and the increase in transactions is substantially related to the government's scheme for naturalization of investors. By exception, 27% of the total property sales contracts submitted to the land registry for the first 6 months of 2017 were related to foreign buyers. In addition, it is noted that foreign investors are interested in prime locations with close proximity to the beach. Clemens in the article Learn About the Elements of a Legally Valid Real Estate Contract mentions that there are some essential elements that make a real estate contract valid. These are the following: legal purpose. It is not allowed to execute a contract that calls for an illegal act. The purpose of the contract must comply with the law and not involve any fraud. Legally competent parties. The parties to a contract must be legally competent to enter an agreement. More specifically, this includes being of legal age and mentally competent at the time of entering the contract. An agreement by offer and acceptance. In real estate, this is represented by an offer to purchase a property by a buyer and the acceptance of that offer by the seller owner. Most preferably, this is not merely an oral agreement but a written contract with signatures of all the parties involved. The buyer is offering a price with contingencies and the seller is accepting the offer with contingencies. Consideration. Consideration is anything of legal value offered and exchanged in the contract. This could be money, services or other valuable goods. The consideration must be defined in the contract. In most of today's real estate deals, money is the consideration. That doesn't mean cash, as there will often be financing involved. Consent. This predefines that the parties to the contract have consented willingly and knowingly to the terms of the agreement contract. There cannot be fraud, misrepresentation, a mistake or undue pressure on any party to the contract. A common misconception is that real estate contracts are overwhelming and confusing. This is not the case. The following steps can help you when dealing with real estate contracts. Try to understand the types of real estate contracts available and how each can benefit an investor. Always read carefully the fine print in any contract.